Welcome, everyone. For those who don't know me, my name is Mark Bracknall. I own a business called Theo James Recruitment, the name behind me there. So we are a manufacturing and engineering recruitment firm based in Durham. The bulk of the work that we do is up north, shall we say, but we also are quite project-led. So we have got some multi-role opportunities across the north. We do a lot of events. So we do quite a lot of face-to-face events. We've just done our first ever Manufacturing Leaders Summit, which was some undertaking. We had 190 leaders in one room at New College Durham a couple of weeks ago, which was amazing. And we'll definitely do that again. But we tend to do a lot of roundtable events. HR roundtable has probably been the most popular. I'm doing another one actually in July, July the 2nd, I think. That will be at SNOP, Automotive Manufacturing Sunderland. So nice, intimate gigs, those. We tend to have sort of 15, 16 people who can get the opportunity to speak to like-minded people. We've actually got a speaker coming to that one as well. So if anyone is interested in that one, please let me know. But we also, of course, do webinars like this because it's just a bit easier for people to access. And obviously, there is a recording. I've wanted to do one around employment law for quite some time. I was just waiting for the right person, which is obviously Keith. And I think what's important to do it now is actually that's time-wise, because if you go back 6 to 9 months, there would have been people who had no real idea about it, no clue about it. Obviously, we're well underway now, and you will all be at different stages of your journey in terms of what you've done or what you're doing. So Keith obviously will have a brief overview of what it is, but actually we're going to get in the nitty-gritty of potentially some of the changes you might not have known about, and some of the things which might affect your hiring, your onboarding, your retention, and all that. You will have an opportunity to ask questions. Please, just as Keith is talking and you think of a question, feel free to put that in the chat. I'll keep an eye out on that. And obviously, when there's moments in the presentation to ask questions, I'll just read them out. Unless anyone wants to, you're absolutely fine to do so. But it's probably easier if I just keep an eye on that and pick out a few. What Keith has kindly said is, if there are questions he doesn't have time to answer, then he will pick those up offline as well. So you definitely get an answer to that. So feel free to do that. But without further ado, I'll pass you on to Keith, who I'm very, very pleased to announce being here. Thank you very much. So yes, over to you, Keith. Thank you very much.
Well, thanks for that introduction, Mark, and thanks as well for the opportunity to speak on the event today. And I also want to recognise all of the people that have put some effort into putting this event together, because I know how difficult and challenging that is. So thanks for everybody at Theo James Recruitment who's put some work into this, and also to everybody online who's taken some time out of a busy day to join us today for today's webinar. So in terms of structure, as Mark said, I have built in some points in the presentation to take questions. So just drop them in the chat, and Mark will pick some out when we get there. But I will, just to repeat what Mark said, provide a draft response to all the questions, and Mark can share those with everybody who's joined. I'll also share the slides, Mark, so you can pass those around as well. And just before we launch into the presentation, I understand we've probably got a range of people or people with a range of knowledge, from sort of very basic up to sort of quite in-depth knowledge of the Employment Rights Act 2025. So I'm sure I'll be covering some stuff that some of the people online already know as we go through, but hopefully everybody will take something away from this morning. So what I'll do now is I'll just launch into the presentation. So Transition HR Ltd is my business. We're going to celebrate our 10-year anniversary later on this year, which is great. So I guess when I started up, as every startup is concerned, you don't imagine what it's going to be like in 10 years' time. And like everybody else, I'm quite sure it was a bit scary at the beginning, I can tell you, but it looks quite good 10 years later. So I'd encourage anybody who wants to go down the entrepreneurial route to take the leap if the time's right for you. But we help organisations with HR support. So we tend to work with SMEs, organisations that where it just doesn't make economic sense to employ somebody in an HR role, or up to the sort of larger SMEs where they do have somebody in-house in an HR role, but maybe it's just part of their role and they're not maybe not qualified or experienced and need some coaching, advice and support to help them deliver that aspect of the role. So we fill that gap as well. So what we're going to do today is we've done the introductions. We're going to run through the scheduled changes with statutory employment law under the Employment Rights Act 2025. And then we're going to have a look at some aspects of case law, because it's not just statutory law we need to keep an eye on. We'd rather learn the lessons or learn from the mistakes of others. That's for sure. And there are still some big organisations making fundamental errors when it comes to decisions they're making within their businesses related to employment. So we'll have a look at a few of those. And then, as I said earlier, we've got the opportunity for questions built into the presentation. So my background is mainly in the private sector. I started out in engineering as a young man, and the last 30 or so years I've worked in an HR role for a few large private sector companies. So you can see from my background, I've worked at every level in a business, from being a young apprentice engineer up to executive director at Hargreaves Services. And for the last 10 years, I've been operating Transition HR Ltd. And my wife and business partner, Kimberly, her background is largely in the public sector, and she has got some private sector experience, but the bulk of her background was in public sector or education. So we make we complement each other basically, and we can cover all the ground that most sectors need from a specialist HR perspective. Launching into the Employment Rights Act 2025, where's it come from, you might ask? Well, you might remember the Labour Party, the current Labour Party, who are in power. This formed part of their manifesto. You might remember the soundbite, which was that they were elected on the back of, which was we're going to introduce a new deal for working people, and that translated into the Employment Rights Bill, which over the course of last year got passed backwards and forwards between the Commons and the Lords, as it does, and then reached royal assent in December last year and is now enshrined in employment law. So there's 28 changes in employment law within the Employment Rights Act, and from my view is that it's the big, I've nearly 30 years in HR, it's the biggest shake-up I've certainly experienced in employment law. And as I said earlier, the changes will be phased in over a 2-year period. We're already past the start line. The first changes came in April. And it's absolutely critical that employers are aware and prepared for these changes. So what are the changes? I want to start with regulatory changes. There's a new agency being introduced called the Fair Work Agency, or the FWA. And that's a new body that's been established on the back of the government's view that there is widespread non-compliance when it comes to employment within the UK. And they've introduced this new agency to strengthen the enforcement of employment rights. So what is their remit going to be? Well, when I speak to our clients, I ask them to think of the HSE, but from the perspective of employment and employment rights. So instead of health and safety, that'll be their focus. So they will have powers similar to the HSE. So they'll be able to visit companies. Employees will be able to contact them with concerns or complaints in the same way as employees can, contact the HSE. And then they will, where they see fit, get in touch with employers. They may do unannounced visits or announced visits, and they'll check things. So what will they be checking? Well, they'll be looking at things like employment contracts, employment policies, pay systems. Are we paying the minimum wage? Are we doing right to work checks when we're employing people? Let's have a look at your payroll. Is everybody in your payroll actually an employee? You might be surprised to hear that it is a thing that some employers, unscrupulous employers, will have ghost employees within their payroll. Are we complying with agency worker rules and so on? And what they'll be able to do, the Fair Work Agency, is they'll be able to, when an employee thinks they want to raise a formal claim through the employment tribunal with their employer, they'll be in place to advise them and help them do that. And even more surprisingly, they'll be able to represent the employee at the employment tribunal. So who's going to pay for all this? Well, the taxpayer. The only time the person that they're supporting will pay anything is if they have a successful claim, and the FWA will close some of their the costs associated with some of their time back from the compensatory award. So, tongue in cheek, my question is: have the government become a no-win, no-fee lawyer for employers? It seems that way to me, and the taxpayer is footing the bill in the main. The next 2 points are potentially, my view is these are the things that might catch employers out. So from October 2026, the time limit to make a claim at the employment tribunal will increase from 3 months to 6 months, and the ACAS early conciliation will be extended from, currently it's 4 weeks, isn't it? That'll be extended to 12 weeks. So if you put that back to back, we're looking at, you could be 9 months down the line after somebody's left your business before that ET1 form, falls into your inbox. And by that time, of course, memories are faded, and it just emphasises the importance of keeping good records when you're dealing with employment issues in the workplace. But what I would say is that October, the first date, it isn't a fixed date, because it is retrospective in that, from the perspective that if somebody is still within the 3-month limit as it is now, on the 1st of October, then that period for them to make a claim will increase to 6. So you need to work or think 3 months backwards, which takes us to the 1st of July. And also the reduction in service to claim unfair dismissal that comes into force in January next year, that is also retrospective. So the qualifying service will reduce from 2 years to 6 months to make a claim for unfair dismissal. But that 6 month service isn't from the 1st of July onwards, it's from the 1st of July backwards. So that again, 1st of January backwards. So that again takes us to the 1st of July. So our advice is to our clients is take advice if you're considering dismissing somebody without following the ACAS code of practice. So short service dismissals after the 1st of July, absolutely take advice before you do that. And then moving on, some of the things that have already come into force, and I think most people will be aware of these things, but worth just covering the points for completeness. SSP, statutory sick pay, the waiting days have been removed, haven't they? So that means that the entitlement to sick pay is a first day entitlement. And paternity and parental leave, there have been changes in those areas as well. So paternity leave has become a day one right. But just to keep us on our toes, the change hasn't been applied to statutory paternity pay. So you still have to have 26 weeks service to accrue the right to statutory paternity pay. Parental leave has also become a day one right. And what I find talking to employers is that parental leave doesn't seem to be on everybody's radar. Not a lot of people are aware of what parental leave is, and in some businesses, my view is rather than sort of keep it under the radar, it could be helpful to communicate and clarify what parental leave is. So parental leave is leave that an employee can take. It's unpaid during during the period from when a child's born up to the age of 18, and an employee can take, or a parent can take, up to 18 weeks off unpaid in that period. They can take a maximum of 4 weeks in a year. You have to take it in 1 week blocks. But very few people, in my experience, take parental leave, and largely because many people are unaware that it exists. But it could be very helpful for parents when they do need some time off. So worth maybe clarifying what that is within your businesses. Whistleblower protection is being extended as well, and what that is related to is sexual harassment disclosures. So you might remember that in October 2024, new rules came into force around preventing sexual harassment in the workplace. Employers were given, or a duty was placed on employers to take reasonable steps to prevent sexual harassment in the workplace. So what did that mean? Well, it meant having a standalone policy on the subject within your business, communicating the existence of that policy, training managers so that there's awareness at the leadership level, providing or clarifying the route to raise a concern if anybody felt that they were exposed to sexual harassment, and carrying a risk assessment in your business. So that has been added to the list of qualifying disclosures under whistleblowing from April, from last month. So what are qualifying disclosures? Well, it's things like criminal activity within the business, fraud, health safety concerns, environmental concerns, and people who raise a concern of that nature are protected from detrimental treatment under the whistleblowing protection rules. Well, sexual harassment claims has been added to that list. That's what that means, and confidentiality clauses or NDAs have become void as well. So you can't introduce clauses of that kind related to sexual harassment anymore. And also something that went slightly under the radar, I think, bereaved parents paternity leave that was introduced last month as well. It's an unpaid day one right, and it allows it's probably going to be something that's very rare, a rare thing for that we'll experience, thankfully, but it allows surviving partners up to 52 weeks of leave if a mother or a main adopter dies within the first year of a child's birth or adoption. And that leave needs to be taken in a continuous block. So moving on to the October changes, the enhancement of the duty to prevent harassment in the workplace is coming into force. So I talked earlier about the duty that came into force in October 2024 to take reasonable steps. Well, the word all has been added to that. So employers will have to take all reasonable steps to prevent sexual harassment, which is a broader duty, and is going to extend to third parties, so people outside of your business. So if you have staff that are customer facing, or deal with suppliers, or the general public, we are going to have to take steps to prevent them from being exposed to sexual harassment from third parties as well. So that means that our risk assessments are going to have to be reviewed further from that perspective, and we're going to have to take more steps. So it might mean that females, for example, I have clients who are estate agents, for example, and have women who show people around houses and such like. They already, because of Susie Lamplugh years ago, have got things in place, but they're going to have to do more to make sure, maybe double up or take other steps to protect women when they're in those situations. The other thing that's changing is fire and rehire is being banned. So again, there are some unscrupulous employers who would break employment contracts to avoid staff from accruing statutory rights with service, and then re-engage the same people a week later under new terms and conditions with a new start date. Well, that practice is being banned and will become automatically unfair from October. And beyond that, from October, there are going to be some new trade union rights coming into play, and in particular, on commencement of employers' employers are going to need to provide a written statement informing workers of their right to join a trade union. And then the government are currently considering whether there'll be a need for reminders to existing staff at a frequency that they're going to confirm. That's probably going to be annually. And what will the statement need to contain? Well, it'll be listing what benefits joining a trade union would bring. It would also include a list of trade unions that an employee might want to consider joining. And that, as I say, is going to have to be provided in a written notice. The government have said that they're going to provide a template that employers can use that will be a qualifying statement prior to October. So we'll wait and see what that's going to cover. And then the last thing to cover on this subject is on the hospitality side. So anybody that works in hospitality will be aware that there was an act covering tips that was introduced in 2023, and that is a code of practice on fair and transparent distribution of tips. Well, that's been enhanced as well in October. So that's the detail of changes that are coming into force over the next 12 months or already have come into force. There's more, as I said earlier, there's 28 changes in total. And beyond 2026, 0 hours contracts, the rules around 0 hours contracts are going to be revamped. And that's going to give people on 0 hours contracts the right to have guaranteed hours after a 12-week reference period if they've consistently worked a number of hours during that period. And it's also going to require employers to give reasonable notice of shifts and compensation if shifts are cancelled at short notice. And short notice is within 7 days. There's going to be more family-friendly changes coming in. So protection for dismissal of pregnant workers and new mothers. That was obviously already protected, but there's going to be more protection. So from the moment an employee informs their employer that they're pregnant to 6 months beyond their return to work, there's going to be extended protection. And bereavement leave, it is quite a shocking indictment, isn't it, that there is no bereavement leave, statutory bereavement leave in this country unless in a sad situation where it's a child that's passed away. So there's going to be some new statutory bereavement leave come in next year. And then flexible working requests, employers are going to have to prove that they've met strict requirements if they're refusing flexible working requests. We already know there's that list of reasons why an employer can refuse a flexible working request. Well, those are going to have to be strictly applied in the future. And then collective redundancies, for those who are a bit long in the tooth like yourself, will remember when this came in, which was on the back of the Woolworths closure. So before that, collective redundancies were within an organisation wherever their business units were geographically located. But after Woolworths, it became at a single location. Well, that's been reversed next year, so we're going back to the 20 employee threshold for collective redundancies. That's going to be aggregated across all sites rather than by location. Schools of thought on whether that's a good or bad thing. And then there's going to be more changes to rules on trade unions as well, particularly around balloting next year. So as these changes come in, rather than swamp our clients with too much information all at once, as these watersheds come in October next year, this year, April next year, we're going to be back talking to our clients and explaining what these changes mean in more detail as the watersheds approach. So Mark, as we've gone through that, has there been any questions come through as we've been talking?
Yeah, there is, Keith. So I'll go through these. So Donna asked this question here, which is a good question. So with sexual harassment, now it is all reasonable steps. What would you consider all reasonable steps to be? So she said they've implemented policies, visuals, manager training, risk assessments, including third party. Should anything else be considered? Has she missed anything off that list that you recommend, would you say?
It's as long as the policy has it, and I'm sure it will, Donna, have a clear route for individuals to raise a concern, and then you're ahead of the game by including third parties. So what I expect some of the maybe larger employers will be doing is they'll be writing out ahead of October to their suppliers, and they'll be asking the question, have you got this covered? Have you got a policy and etc. Train your managers and so on. can you guarantee to us, that these steps have been covered? So I think that's the next thing, to go beyond your organisation and ask the third parties that you work with to verify that they have also taken reasonable steps. And when it comes to your risk assessment, to just review and refresh that and consider third parties. And obviously we're very much focused on women, female employees here. Although it might surprise you to know that more than 25% of all sexual harassment claims come from men, and that tends to be homophobic type stuff in the main, and often when the guy isn't gay but have been exposed to homophobic comments in the workplace. So it does happen, but these new rules, let's be clear, are very much focused on protecting women and girls in the workplace.
Thanks, Keith. The next one's from Gail. Will the length of service for statutory redundancy payments still remain at 2 years service, i.e. you won't drop to 6 months?
Yeah, there's no change to the statutory payments related to redundancy, no.
Great. Okay. Kaylee here. Which of the new rights do you think will create the biggest operational challenge for SMEs?
Well, as I said earlier, I don't think it's any of the policy level changes that are going to cause issues for employers. Employers will adapt, they'll amend their policies, and in the main will comply. It's more the regulatory changes.
Okay.
So it's a big change to the unfair dismissal, reduction in qualifying service claim unfair dismissal to 6 months. That's a massive change. The employment tribunal system's already overburdened. So this is going to bring in a whole suite of new claims, in my view. And the introduction of the Fair Work Agency as well is going to compound that. Once that gets down the road a bit. So I think it's the regulatory changes, and in the short term, as I say, in the period between the 1st of July and the end of the year, I would really encourage employers to be very careful.
So Donna's got a couple of questions here, and so the first one she typed in, the second one she's asked to be muted because it's probably a bit more complicated. So Donna, I've unmuted you there, so you can ask away whichever you want. So you should be able to talk, hopefully.
Lovely, thanks. So the one I wanted to be unmuted for is flexible working, because it's a little bit difficult just to type it all in. And I can see with your background, Keith, from Calsonic, that you'll possibly be familiar with the environment. I mean, I work at Highly Morale, so we do the HVAC units, and we are getting more and more requests, flexible working requests from operator level, where they only want to do 4 days a week, for example. And we haven't currently to refuse these requests, because to try and get somebody to reliably cover that 1 day is nigh on impossible. How will that sit with the new rules of having to prove that you're doing everything reasonable to put these flexible working requests through?
So again, it sounds like you're doing everything that you need to do to comply with that. You'll be sticking within the time limits. You'll be having meetings, and you'll be keeping good records all around that. That's always important. The record keeping side of things. You just have to be seen to be to have made the effort. But by that, what I mean is, in a case where shared working is requested, then have you advertised, and can you show that there weren't any applicants, and so on. It's that type of evidence that you would need if you were ever challenged.
Oh, okay. No, that, I mean, we do that, and I think if it was a true job share, it probably would be less of a
Yeah,
a
yeah. So
problem.
it's job share
But when it's
50/50 or
just
yeah,
one day for 8 hours, it becomes increasingly difficult
yeah,
because of things like universal credits and things like that. People don't want to just work 8 hours; they want to try and hit them 16 hours to maximise the benefit system if that's what they use. And so I just wanted to check because I just do feel like the flexible work and people are much more aware of it. They're making much more requests. We might have people who are coming close to retirement who think, actually, I could just do with dropping a day or so.
yeah,
And work on a manufacturing line, as I'm sure you'll be aware, it's difficult to do that. You've got your heads to get the parts out, and you can't just work with one less head for one day. It doesn't work very well if you then counter into possible sickness or holidays and stuff that you may have ongoing. So I just wanted to check like whether this was potentially going to crop up as a huge issue coming into play a little bit stronger.
Well, Donna, and what I would encourage you to do is push it back to the employer, to the employee to an extent as well, and ask them, you know, when you say we can't accommodate, you know, because, and it's not just the difficulty in recruiting, it's the increased costs as well, isn't it?
It
Training,
is.
uniforms, equipment, all that sort of stuff. So, you know, explain to the individual, you know, after you've verified that, you know, it's impossible to recruit and you've got the evidence behind that, ask them if they've got any alternative proposals. Because as you've said, you know, in a limited way, you might be able to accommodate more of a sort of 50/50 or 60/40 job share situation, but just not 80/20.
Yeah, no, that's right. And then my final one was hopefully just a really quick one. I'm just wondering when the trade unions come in and we have to do like a written statement to employees to say that, you know, you do have the right to join one, these are the benefits. Are we able to do like a Works Council first trade union on that, or will it just be purely communication for trade union? Just because I know obviously we do internal works council, it works much quicker than a trade union when it comes to
Yeah.
pay awards, etc. So like, can you do that sort of comparison, or would that be frowned upon?
No, I do. I think you should. You know, if you've got something in place that works perfectly well now, and maybe, you know, better than what a trade union recognition arrangement would work like, I think you absolutely should. You know, communicate that as well. There's no rules to say that you shouldn't, and it shouldn't be a free ride for trade unions, should it really? And you've seen my background at Calsonic. We actually had a trade union recognition request during my time when I was there, which we successfully averted by doing exactly what you just described.
Yeah. Okay. No, that's great. Like I say, I don't think the employees always consider things like pay awards could be massively delayed if there's a huge negotiation going on, where when it's done through the Works Council, it's normally agreed within about 4 weeks.
Yeah, my
So
experience is similar. Find that employers are there's less trust with a third party trade union and are much more guarded, and you know, time frames, you know, are much longer when you're dealing with trade unions as opposed to your own staff under Works Council arrangements. The unions will say, well, it'll be your staff anyway, because, you know, the people that are elected as representatives, you know, will be in a lot of cases existing staff, but I still think because there's, you know, the union in the background, trust is reduced and timescales are extended for that reason.
lovely. Thank you. Well, I'll jump off and let somebody else jump in now. I've taken enough of your time. Thank you.
One quick question here, Keith, which should be quite a quick one from Stacey. Collective redundancies, does this only relate to sites within the UK, or does it also apply if other sites within the global business are also making redundancies at the same time?
Yeah, just the UK.
Okay. Yeah. Perfect. So that's that's a lot of questions for now.
Well, I'll move on to some interesting bits of case law, which interesting to me. Hopefully, you guys will find interesting as well. And as I said earlier, this is about learning from the experience of others where they've made mistakes, and it does continue to surprise me that large employers still make fundamental mistakes. So in this case, this was a lady who worked for Quarterfields Health Care Limited. Beatrice and Bonda was her name, and you can probably assume by her name that she was a black lady, or she is a black lady as far as I'm aware, still. So she worked for Quarryfields, and some other employees complained to management that she was asleep on night shift. And it just so happened that the three complainants were white, and Beatrice, denied that she was asleep on night shift, and said that this was, a race issue, and challenged the complaint from that perspective. But the employer said, well, we've had a complaint, we're going to have to investigate it. So they appointed an investigatory officer who did carry out investigation and recommended disciplinary action. So disciplinary action occurred. All through this, Beatrice was under the threat of a gross misconduct dismissal. So obviously stressful time for her. But ultimately, the employer gave her a final written warning, which he appealed against. But the manager chairing the appeal upheld the original decision. So Beatrice was disappointed with all this and decided to leave, and claimed constructive unfair dismissal and race discrimination. And as it went through the tribunal system, it was established that the original person who was investigating the issue didn't speak to everybody on the shift that they could have. They spoke to Beatrice herself, they spoke to the three white ladies who made the complaint, and one other black person who said they didn't want to be involved and wanted to stay out of it, so refused to make a statement. But there were other people on that shift and other black people on that shift, which the original investigatory officer decided not to speak to. And then when it got to the disciplinary stage, the disciplinary officer relied solely on the report from the investigatory officer, and so did the appeal officer. The tribunal panel believed that showed signs of predetermination from the outset, because there's three stages to the disciplinary process, isn't there? There's the investigation, there's the appeal, and then there's the hearing itself and the appeal. And there's a requirement, where possible, to have three different people, independent people, chairing each of those stages. And what that person should do, they should go back to the beginning and make sure that the person that dealt with the issue before them covered all of the relevant ground. In this case, that didn't happen. So the tribunal found in favour of Beatrice in that she was unfairly dismissed, and they upheld her race discrimination claim, and she was awarded over £23,600 in compensation. So the lesson there is to make sure that each stage of the disciplinary process, there's a fresh. We look at it with a fresh pair of eyes. We go back to the beginning and we make sure that all of the proper ground was covered before. We don't just rely on a report from the person that handled the issue previously. And if you wanted to look up that case, the case number will be on the slides when we share them. This one was a shocking case, unfair dismissal. Paula Smith versus Northwest Ambulance Service Trust. So Paula Smith is a gay woman, and she was married to a lady called Stacey Smith. They both worked for the Northwest Ambulance Service Trust, but they were on different shifts, and they requested that they be placed on the same shift. They made that request to their employer. They made that request on several occasions. It was always denied. I don't know why it was denied. Maybe they had specific skills that were needed on different shifts. But it was denied. Over an 18-month period, these requests went in and they were always denied. So Stacey Smith, shockingly, decided that it would be a good idea to go and knock on her operations manager's door, drag her out onto our driveway and beat her around the head with a hammer. resulted in her being arrested, and she was given a 20-year prison sentence for attempted murder. So what does the employer do with Paula Smith was the question. So they brought Paula Smith into a disciplinary meeting, and they said, well, ultimately, Paula, we can't have you continuing to work here because of your ongoing association with Stacey Smith, because patients and the general public just would have an issue with that. So it's a reputational thing for the ambulance service. So they sacked her. So Paula Smith took a claim to the employment tribunal, and her claim was successful. She was unfairly dismissed according to an employment panel, judge and panel, and that was because the reasons they gave was the reason in the principle was the reason given to dismiss Paula was that the general public and patients would have an issue, but Paula Smith was interviewed by the police but never charged with anything, and all of the publicity related to the case didn't mention her name. So the employment judge took the view that it was unreasonable to believe that the general public would even know that Paula Smith had anything to do with Stacey Smith. So this principle of innocent until proven guilty was quoted by the employment judge. And what we do occasionally get inquiries from clients along the lines of, a member of staff was arrested over the weekend. What can we do? Or what should we do? And this principle of innocent proven guilty, is a factor. So what can you do? Not a lot, really, because just because they've been arrested, maybe not charged with anything, or even if they have been charged, they haven't been found guilty. So the options really are just you can suspend the person if you feel that that's the right thing to do. That the issues in play are so serious that you maybe want to suspend. But suspension is on pay, and how long does it take for a court case to go through the system? Years in some cases. That would be a long time. You could obviously make some changes to the working arrangements. Ask the person to work from home, for example. But a large number of them, jobs you can't work from home, so that's not practical in a lot of cases. So it's difficult. So the lessons here are dismissals whilst the criminal investigation is ongoing requires a thorough and fair process, obviously, and rather than relying solely on the accusation itself, the employer should review other issues. For example, if Paula Smith was arrested and was remanded for a period, she wouldn't have been able to attend work, and frustration of the contract might have been a fair reason for dismissal because of her inability to attend work. But that's not the route they went down, and that was found to be unfair dismissal. The last case I wanted to cover, this is a case that I use a lot when I'm delivering training around employment law, and it's just a case that I found that does show how often the viewpoint can change when you're going through the different stages. So this was a case where there was two young lads who were working for Liverpool City Council. They were electricians, and they were found to be doing work in company hours, using company equipment for cash in hand. So we would call it a govy job. Scousers in their sort of parlance call that sort of thing doing a foreigner. So that could have a few connotations, couldn't it? So I thought I'd just better explain that. So it just so happened that the maintenance manager lived on the street where this work was being done on this particular day. So as he was driving to work, he passed the Liverpool City Council maintenance van and thought, I can't remember booking anything in here this week. So he found out who was using that van that week, and he brought the two lads into a disciplinary process. And they were ultimately dismissed because of that. So they appealed, and Liverpool City Council, obviously you'd expect to be unionised, so they were represented by a union. And the union guy said to the appeal manager, has this happened before? Now, obviously, I'm assuming he'd done his background research, and he knew it had happened before, but the appeal manager said, I'll go and check and we'll reconvene. So he went and checked, he came back and he said, yes, it has happened before. And the union guy said, well, what was the outcome? And the appeal manager said, well, the outcome was a final written warning. And the union guy said, well, that's my guys reinstated then, isn't it? And the appeal manager said, no, they're still dismissed. So this went to the employment tribunal, and the arguments were put forward, and the tribunal agreed with the employees and said that was an unfair dismissal. But Liverpool City Council appealed to the Employment Appeal Tribunal. And what they put the appeal tribunal was that the guy that had been caught doing a govy job before and given a final written warning was 64 years old. He'd worked for the council for 40 years. He was 6 months from retirement. So they decided to be lenient in that case. Whereas the two young lads, they were in their mid-20s. They had another 40 plus years of opportunity to do this sort of thing and basically rob the taxpayer and be, fleecing the council by doing this sort of thing, and they weren't prepared to take that risk. So the Employment Appeal Tribunal did overturn the original tribunal's decision, and that was ultimately found to be a fair dismissal. So that case just goes to show how decisions can flip-flop, and the devil's always in the detail, isn't it, when it comes to decisions in those areas. So were there any other questions, Mark, as we went through any of that?
No, I don't think so, mate. I don't think so. What I was going to say is, obviously, we've scheduled it till 10 to 11. If you have got obviously more in presentation, it goes past 11, and people need to jump off, no problem, because remember, it is recorded, so I will send you the recording. So if needs must, you need to skip to the end and watch it, that's absolutely fine. So, but no questions on that one, Keith.
Mark, so no worries. We're at the end. We'll be finished by 11. So just a summary, really. 28 changes of employment law being rolled out under the Employment Rights Act over the course of the next 2 years. I think it was a question earlier, wasn't it? But my view is the introduction of the Fair Work Agency, the extension of the period to register the Employment Tribunal claim 6 months in October, and the reduction in the qualifying service for unfair dismissal in January will be the most impactful, and take real care if you're letting anybody go after July the 1st. So we're working with a number of employers with the aim of improving absence monitoring because of the changes in SSP, to help them monitor and manage absence with the aim of maximising attendance. I think it's just brought into focus and the attention of employers that, the fact that people might take more time off if they're going to get sick pay from day one. That's a worry.
Yeah.
And it'll be, it's always a business critical issue, recruitment, but it's going to be even more of a business critical issue, in my opinion. Because of the changes. So really, we want to make sure that employment documentation and practices are compliant, that recruitment selection processes are robust, you're getting the right people in, don't take any chances in recruitment. And probationary reviews, my advice to our clients is make your probationary period 6 months if it's not already. Make sure you review, not just at the end of that period, but at least once, if not twice, you carry out a review, an onboarding review with new staff during that probationary period. And if you've got any doubts at all, the days of extending probationary periods are in the past, in my opinion. We shouldn't be doing that. We should be making decisions during the probationary period. And if there's the odd employee that we've got doubts about where we think this might not be the right appointment, then deal with that during that 6 months. Don't let it go a day past.
Yeah, it's a really interesting point there, because we've more so the earlier definitely found that trap of, we're not sure, we'll extend it 3 months, and 90% of the time, probably even higher, they don't last.
Yeah.
So I think you're right. It's just getting that. Very quick question here from Gail. She said, I've been advised to reduce from 6 months probation to 3 months. So I'm presuming, based on your feedback there, Keith, that isn't good advice.
Well, I would. It's not my opinion. My opinion is the opposite. Go to 6 months, but carry out reviews during that period.
Yeah,
that's the advice we're going to. Every advisor, my other advisors might have a different opinion, and I can't comment on that.
Yeah, no, we moved to 6, and like I say, I felt it did make a difference, and took out a little bit of the stress away from both sides. But like you say, it's that those regular touch points, and document those touch points. Kaylee's on the call, who's my operations manager, also doubles up as HR, and she makes sure I document everything we do. So yeah, but it does make a difference, to be fair. So look, thank you so much, Keith. That's really, really helpful. I've learned loads. So if anyone does have any other additional questions, feel free just to put them in the chat, and then obviously Keith will pick those up outside. I'll also make sure you got the recording. I'll also make sure you got Keith's details to contact. I mean, what's the best way generally, Keith? Obviously, I will send them your details, but just LinkedIn, email. What's the best typically?
Yeah, just email. It'll be fine. No concerns about sharing my email address, Mark. Yeah.
Yeah, thank you. But thank you for everyone. Thank you very much for jumping on today. I really appreciate it. I will make sure I'll send you the recording, and I'll say, if you have got any more questions, please drop them in, and I'll make sure they get answered. But thank you very much. Much appreciated.
Thanks, Mark.
Thanks, guys. Thanks very much. Thanks, Keith. Thank you very much, buddy.
You're welcome.
Speak soon. I'll just wait till everyone drops off. But yes, thank you, Keith. That was great. Really enjoyed that. Thank you very much.
It's good. Yeah.
Yeah. So I'll share the recording out for people. That'll probably be with us, sorted next week now. And is that okay if I just send your details to them as well, and advise if they've got any questions, just to reach out? Is that all right?
Yeah, by all means, and I'll send across the slides that I used this morning.
Yeah, thank you. Because we just had a question just at the end, which I missed actually. So I'll drop that across to you.
She was asking about. I think I did explain it. 6 months. I think she's asking about. By the time you get to 6 months, it's probably too late. So I agree with that, and we should carry out or reviews during the probation period, don't we, at the end?
Yeah, I completely agree. Excellent. Well, thanks again, Keith. Massively appreciate it. Thank you so much. And I'll have a catch up with you next week. But yeah, thanks again. Really appreciate it, buddy.
Okay, that's great.
Take care, mate. Speak soon. Cheers,
Bye-bye.
mate. Bye.